Hello everyone, hope you have an amazing day and welcome back to my blog. Today we discuss about Statutory Compliance Guide, a detail of all acts and including labor laws. Now, statutory compliance of rules and regulation in payroll HRMS is a grave legal matter for both employees and the organization's social security. The Indian government has declared various regulation and act to process employees' payment. Every company is liable to follow these rules to avoid legal consequences. Whether to follow it or not might be a company's individual's decision, but it may have some severe implications. Now, what is statutory? The word statutory can be defined as enacted by statute or regulations, and compliance means agreement. Combining statutory compliance forms agreement of regulations or to follow regulations. Now, statutory compliance adherence provides a great deal of security, starting from employees' minimum wages to the company's business existence. Every country develops its own set of rules for organizations to follow that adds up early or every year. Organizations put a lot of effort and money to adhere to these laws. However, it is not possible for every organization, especially SME, to invest a lot of money in this. Now, why is statutory compliance important for an organization? Statutory compliance in HR is an important as seen for the both employee and employers perspective. Indian government provides employee benefit acts like industrial relations, minimum wages, social security, women and child employment, health and safety, and organization benefits acts like provident fund, trade union, employee state insurance, that is ESI, professional tax, etc. We will further check all the details of this act. This act can vary from state to state and country to country in India. These acts sometimes change for every state but not necessary. Non-agreement to such laws implicate legal consequences on business existence. That is why business representative put a considerable amount of money, time and people to adhere to these laws. Additionally, they also seek laws and financial taxation expert advice. To be a statutory compliant company, you must practice an efficient way to minimize this risk and update them with these laws. Every type of organizations, whether private, LLP, partnership based, which provides a salary to their employees, must stick to these laws to avoid reputation and business threats during any statutory audit. Now, these regulations are checked during the statutory audit. A statutory audit is an inspection that is mandated by law to ensure the books of accounts presented by organizations are true according to the statutory audit checklist finalized. Now, statutory benefits applicable for employees. Number one, ensure minimum wages and equal remuneration to men and women, fair treatment to employee and betterment of industrial relations. Number two. Number three, help avoids inhuman conditions of work and guarantees workplace health and security. Number four, provides social security through compensation and incentives. For employer, protection to the organization's existence, protection against illegal wages damage from trade unions and employees, both, maintenance the organization's reputations and client engagement, no risks of fines and penalties in organization. Now, disadvantages to non-adherence, financial threat and losses, arouses employees' conflicts and trust issues, a warning to the organizational existence, clients' trust issues for the organization. The government deployed rules and regulations. Take a look to the some of the central government deployed rules for organizations who employs works. If you find these rules are overwhelming, you can consider using Factor payroll software. Now, labor laws in India for private companies are the same throughout and don't change for a specific company. Rules regarding HR compliance are distributed to specific sector. Equal Remuneration Act 1976, Maternity Benefits Act 1961, the Payment of Gratuity Rules 1972, the Industrial Dispute Act 1947, that is Industrial Relations, and the Employees Compensation Amendment Acts 1923, Social Securities about, the Employees Provident Fund and Miscellaneous Provisions Amendment Act 1952, the Employees State Insurance Act, that is ESI Act 1948. Now, wages related, the Payment of Wages Amendment Act 2017, number of 1 2017, Minimum Wages Act, that is 1948, the Payment of Bonus Amendment Ordinance, that is 2007, Industrial Relationship, Women's Benefit, Social and Medical Security, and Wages also. Now, Industrial Relations Guide for Statutory Compliance, the Industrial Dispute Act 1947. In details, the Industrial Dispute Act enacted in 1947 to make provisions for investigating and settling disputes between employee and employers, or employee to employee and employee to employer to employee. The main objective of this act to maintain peace and harmony in work culture in India establishment. This act applies to the whole Indian nation, including establishment for business, trade and manufacture and distributors. However, it does not encircle persons in the managerial and administrative field and persons subject to Army, Air Force and Navy. Now, Women Benefits, Equal Remuneration Act to 1976. As the name suggests, the Equal Remuneration Act encloses a gender-based payment equality policy of industry. It ensures uniform payment to the employees irrespective of men or women to avoid gender bias. It came into the picture because payment given to women was lower than that of men. Through the work among being the same, non-compliance with this act can implicate serious fines and penalties also. Provisions under this act include: 1. Not the reduce employees' salary to adhere to the act. 2. For the same nature of the amount of the work. No discriminations is allowed for women. During the formation of an advisory committee that works to increase employment opportunities for women, work hours and its nature shall consist of half women members. Now, Maternity Benefits Act 1961. The Maternity Benefit Act was passed in 1961. Therefore, an appropriate leave management software helps HR ensures such laws. It also provides them certain months of paid leaves during their maternity to take care of the child. And after maternity, she can continue with her job without any disturbance of maid leaves in organization. This act applies to all establishments like factory, shop, private and government sector with 10 or more employees during her maternity, and she will be paid based on average daily wages. But to gain this benefit, she must be working for an organization for at least 80 days within the past 12 months. Further amendments of this act in 2017 guarantees increased amount of paid leaves during maternity leaves are increased from the existing 12 weeks to 26 weeks. Leave for adoption. Women can leave for adopting a child below the age of 3 months, and the commissioning mothers. Work from home option. Woman can now continue her work directly from her home with no leaves requirements and is comfortable to her. Now, the Social Security. The Payment of Gratuity Act 1972. The Payment of Gratuity Act guarantees benefits like gratuity and incentives to the employees working in railways, mines, factories, ports, oil fields, shop and private sector also. A certain amount is deducted from monthly wages and further provided after an employee's retirement, offering monetary help called gratuity. Gratuity is allowed to an employee who has given continuous service for at least 5 years for a particular organization as per section 4 by 1. Gratuity is mandatory payable for employee death or a disablement even through 5 years for service is pending under section 4 by 3. The maximum gratuity amount an employee is beneficial for is rupees 20 lakhs and is liable to tax for gratuity amount more than stated. Now, according to section 1 by 2, state Jammu and Kashmir are not liable for this act for plantations for port as per section 3 by 4, 3 by A, in case the employee rate somehow drops below 10 for an establishment. The employer must not request for reducing gratuity under section 2 by E. This act does not apply to apprentice or civil service employees under the central and state government both. Now, gratuity depends on the year of service and the last drawn salary and is calculated according to the formula. Gratuity equal to last drawn salary, number of completed services year 15 by 26. According to the above formula, these service year will more than 6 months will be considered one full year and less than 6 years will be regarded as 0 years. For example, a service period of 7 years and 8 months will be 8 years and a service period of 6 years and 4 months will be 6 years. Now, the Employees Compensation Amendment Act 1923. Many services involves hard work, risk of losses, critical injuries or even death. Employees Compensation Act enacted in 1923 protects an employee or his or her dependents through compensation during any condition mentioned above. According to section 17A, every employee must be well informed about his compensations at the time of joining by the employer. Failure of such tasks may result in penalties and fines of rupees 5,000 to 50,000 as imposed by government under section 18A. Now the Employees Provident Fund and Miscellaneous Provisions Amendment Act, that is 1952. The Statutory Provident Fund Act is issued for the social security of the employee. Employees Provident Fund Act is liable for any establishment employing more than 20 employees to make this possible. Every employee during his or her employment contributes some amount from their salary to the Provident Fund PF. Even their employer is also required to continue or contribute to his fund. Companies can also invest in the Provident Fund solutions to manage their employees' funds. The fund then ensure social security after employees' terminations or retirement. EPF, Employees Provident Fund, of every corresponding employee must be deducted from his or her salary and filled before the PF return due date, which is the 15th of each month. Now, employee PF calculation is based on basic salary and DA. Other allowances like HRA, human resource allowances, overtime allowances, incentives, etc. are not included under this act. These basic wages covered in this is rupees 15,000 monthly. Provident Fund PF divides into two funds, EPF, that is Employees Provident Fund, and EPS, Employees Pension Scheme. Consider the following PF rates declared by the government. Now EPF 12 of gross, that is 3.67%. EPS employees 0, employer 8.33, or total contribution 12%, employees, and for employer also 12%. So now the Employees State Insurance ESI Act 1948. The Employees State Insurance Act ensures absolute medical security, including sickness, maternity leaves, and injuries for employees working in non-seasonable factories, including power with more than 10 employees and non-power and other establishment with more than 20 employees. The wage limit covered under this act is rupees 21,000 per month. The act applies to all states except Manipur, Sikkim, Arunachal Pradesh, and Mizoram. Benefits can be availed through ESIC online appointment for hospital, clinics, and practitioners also. Both employees and the employer contributes to the ESI scheme on ESIC payment portal, and ESI percentage contributions made to the same are employees contributions 0.7% and employer contributions 3.25% gross pay. Now tax deducted at source, TDS. TDS or tax deducted at source is a certain amount of money deducted from the employee's payment as an amount of income tax to lower the tax evasions afterward. Employees can file a TDS return for the deducted tax which they can get refunded. Tax slabs, there is tax slabs also. Existing tax regime, that is up to 50,000 and to 5 lakhs. Or so now we discuss about the wages, the Payment of Wages Amendment Act 2017, number of 1 that of 2017. Payment of Wages Act guarantees payment of employees on time without any deductions other than stated by the government authority through, though this does not apply for employees having of rupees 24,000 wages per month. Under Section 4, every person responsible for payment of wages must fix the duration for payment and that should not exceed about a month, meaning an employee can be paid daily and weekly and fortnightly or monthly under Section 5 for a railway industry and other establishment with less than 1000 employees. It must processes the payment till the 7th of the subsequent month, which exists 10th of this month for establishment with more than 1000 employees. Now the Payment of Bonus Act Amendment 2007. Payment of Bonus Act ensures annual bonuses to be paid for employees in establishment including factories with more than 20 employees. The year bonuses is calculated based on the employee's salary and profit of the establishment. Any employer ensures that the bonus paid must be minimum of 8.33% and the maximum of 20%. Employees with salary 21,000 rupees or less or equal for a bonus after working of rupees 30 days in an establishment. Bonus payment must be provided within 8 months from the beneficial financial year closing, and these bonus must only include basic and DA and should exclude other allowances also. Now, Minimum Wages Act 1948. The Minimum Wages Act enacted in 1948 by the Indian Parliament states that it provides minimum wages salary to skilled and unskilled labor in organizations. The Constitution has defined a specific living wages that includes primary livelihood, including health and food for comfort, education and dignity also. And this act provides for fixing the wages rate for every establishment. Criteria for following under this act. Now I discuss about it. Working hours for a typical day would consist of 1 to 2 working hours per day, must have 1 to 2 breakfast rest and intervals, 1 to 2 at least 1 week off and to be given to the labor, and 1 to 2 per wages must not be any less than given overtime rate also. Now for any employee working for a task that includes more than one employment must be given salary based on each task's working hours. The employer is permitted to maintain records of the pay slips and wages structures of a particular employee. Under this act, the government may notify the employer to revise or fix minimum wages. It includes 2 methods of fixation and revisions also. Committee methods, government formulating committee and subcommittees that inquiries and recommends minimum wages, and notification methods, and the government publishes an official date in the official gazette before all advice and recommendations must be collected. So that's for the end of the video, my friends. If you like my video, please subscribe my channel. Also share and comment on my channel. Thanks a lot for watching.